This is Michael Popok, and you know what time it is. Legal AF After Dark time. Judge Engoron presiding over the biggest death penalty financial threat to Donald Trump that exists, the $500 million or so disgorgement civil fraud case that's been pending against Donald Trump for the last year and a half. He's about to enter his ruling. We've been expecting it for over 3 weeks. We thought it was coming last week. But then something happened. The New York Times reported that one of the lead witnesses for Donald Trump, and more importantly, a defendant in the case, along with Donald Trump, a co-conspirator, if you will, named Allen Weisselberg, the disgraced felon of a chief financial officer for Donald Trump, might be ready to plead guilty to perjury. That means lying under oath in the very case that we're talking about. What could the impact of that be? What will happen with the Manhattan DA's office? You know who knows better than anybody? My co-anchor, Karen Friedman Agnifilo, used to be a leader in the Manhattan DA's office, and we talked all about it on Legal AF. Take a listen. Let's return to that saga. I feel like I'm binge watching the episodic TV here when it comes to the civil fraud case. So let me tell you where we are, and then then you and I can bat it around, bash the badminton around a little bit, the shuttlecock around a little bit about the case. 11 weeks of trial, dozens of witnesses, experts for Donald Trump, all sort of rejected by the judge. Witnesses that testified, including many that for Donald Trump that the judge found to be incredible, uncredible, and not telling the truth, including Donald Trump himself in one scenario. Now it all comes and oral argument was held a month ago or 3 weeks ago, and we've been waiting on Judge Engoron to issue his judgment. Now, first we thought he was waiting to see the monitor's report for the monitor that he had installed 14 months ago, about what's going on currently in the Trump organization. Have they learned their lesson? Are they still committing fraud? How are they running their operation in the lab? Should I allow them to continue? Are they good Boy Scouts or Girl Scouts, or are they recidivists that I should punish? What is it? So he got that report, and we've done a lot of talking about and unpacking of that report, which was closer to a D to an F for the Trump organization than an A or a B. And so I said, all right, well, he's probably waiting on that. And then we get the new bombshell. New York Times starts to report that Allen Weisselberg, the disgraced chief financial officer, already convicted of tax evasion and served 100 days in jail at Rikers Island, who testified. Yes, he was called adversely by the New York Attorney General, but he testified trying to help Donald Trump. Every time there was a question that would have hurt Donald Trump, he couldn't remember. Every time there was a question that could have helped Donald Trump, he suddenly grew a brain and memory banks and testified about it. And in real time, Forbes magazine had a headline that said, Allen Weisselberg just perjured himself because he lied about him pushing as a major part of the assets for Donald Trump the size of the triplex apartment in Trump Tower, which we have a picture up there, which is 1/3 the real, they tripled the size of it, speaking of triplex, and it went from being, maybe a $50 million apartment to, on the books for Donald Trump, a $150 million apartment, which, as you can all imagine, knowing math, that's a big swing to cook your books with. And he lied under oath, apparently, and said, I never told anybody that. I never pushed the size of it. I don't know what the size of it was. And Forbes magazine was like, yes, you did. You gave us an interview in Trump Tower in which you waved your arms around and said, look at this giant 30,000 square foot triplex. And of course, he had already testified and given sworn testimony to Karen's old office. And so the reporting is he's in plea discussions being led not by the lawyers for Donald Trump, but by his own counsel, Seth Klayman at Klayman Rosenberg, to maybe take a plea of perjury and for testifying fraudulently inside of the courtroom with Judge Engoron. So Judge Engoron reads the paper. Nobody thought to inform Judge Engoron officially, like the lawyers. So he had to read it like in the morning paper. He came back to the lawyers with an urgent, high priority email. I love Engoron, and wanted a response in 2 days as to whether it was true, what impact it should have on his evaluating the credibility of witnesses like Allen Weisselberg, if he should just apply the legal doctrine that he's a liar and he lied about everything, and do an adverse inference about it, and how that should impact the judgment. And as officers of the court, I want you all to tell me what happened here. Hint, hint. Did the lawyers for Donald Trump know he was lying and allowed it to happen, meaning they suborned perjury? Let me know. I want to get to the bottom of this. And so we got the filings, which just came in right before we got on the air. Karen and I got on the air tonight, which is from Alina Habba and mainly the New York Attorney General, Kevin Wallace, and Cliff Robert. Karen, did you get a chance to go through all those?
I did. I didn't think
why
I was
don't you take it from here then? Tell the audience about them.
Yeah, look, this back and forth about Weiselberg was fascinating because, first of all, having worked at the Manhattan DA's office and had the New York Times report on our big cases, typically the New York Times does not go out over their skis. I don't think they would have published this if they didn't have pretty good information that those discussions are going on. So that's number one. I think we have to assume that is happening at least at some level. And it was very interesting because some people would think that prosecuting perjury is easy. It's not, because it's like, oh, it's a liar. It's either you lied or you didn't, or you told the truth. But it's not always easy, because when you say things like, I don't recall, it's hard to prove memory, right? It has to be a material misstatement for you to be able to prosecute someone for criminal perjury. And the statement has to be under oath. So the easiest thing would be if you had testimony at the tax fraud case against the Trump organization that they got the 17-count conviction for at the Manhattan DA's office. The easiest thing would be in that trial where if Allen Weisselberg testified to something that he said, the apartment is, I know for sure, I went and measured it, the apartment is 10,000 square feet. But then he came and he testified to Judge Engoron, and I'm just making up the facts because what I didn't do is analyze the record in detail. I'm just giving an example of what could be perjury. And then in front of Judge Engoron, if he testified, no, it's actually a 30,000 square foot apartment, and he lied, right? That's a clear material misstatement of a fact under oath that I think could constitute perjury. The fact that I think they probably have the goods on him. I think there probably is something, and they're negotiating. What do we do? Because don't forget, this not only will impact the Attorney General's case, but this is going to impact the Stormy Daniels election interference case that's about to go, because Weiselberg is a witness in that case. And so, look, it's, when you are calling a witness who's a cooperator to the stand, and then you have to put out there that he's a liar and he committed perjury, he kind of is useless in a way, unless you can corroborate him, because the cross-examination of him is, you lied under oath, so why should we believe you? You're under oath now. I mean, he's a liar. And so it's not good for Allen Weisselberg that he committed perjury. He also could go to jail. They could rip up the cooperation agreement, and the cooperation agreement, which would say, if you violate this, then there's some consequence. That could happen too, and might happen, and he might have to go back to jail. So Engoron is right to want to know about it, and he talked about a concept in the law which is called falsus in uno, another Latin phrase that practicing lawyers, trial lawyers, are familiar with. And it basically means that if a witness lies about one thing, you can assume they lied about everything. It's actually a jury charge that we often ask for when we go to trial, and we're talking about what's the law, what are the charges that the jury is going to be read. And sometimes lawyers can ask for that if a witness if you find that a witness has lied under oath, you can choose to disregard everything they said and assume everything they're saying is a lie. And Judge Engoron talked about that. I could do that. It's one of the things he could do, but that he obviously wants to know. And so the letters today, and he said, so parties, I read the paper, I want you to get back to me and tell me what your positions are, and tell me what the law is, and what should I do here. And the Attorney General's office said, basically, they wrote a letter and letter brief by Mr. Wallace, who basically said, look, what we have done in our office is what we have to do, which is we built a wall, and there is somebody who is dealing with the Weiselberg perjury criminal side of this and talking to the Manhattan DA's office. I'm on the civil side, and so that's what I'm dealing with, and we have to deal with it this way. But he basically cites a New York ethics rule 3.3 AC, which creates a disclosure obligation to a lawyer if they basically knowingly call a witness to the stand, or if their client, let's say, so here it's his client, but they didn't call him to the stand, right? The Attorney General's office called him to the stand. If they know they're an officer of the court first and foremost, if you're a lawyer, right? You represent your client, but you also are an officer of the court. That's why you have to be an attorney in good standing of a particular court to be able to practice there. And so, because you have obligations, they're giving you permission. A court gives you permission to practice there. And if you're not barred in a certain jurisdiction, you have to ask for permission and be sponsored by a lawyer, because you have ethical obligations. And one of them is that you're not going to knowingly submit false information or suborn perjury to the court. And so the Attorney General reminded the court of the ethical obligation that Alina Habba has, that basically says, look, you have to disclose to the court if your client or a witness that you called gave a material falsehood, you're obligated to tell the judge. And what the Assistant Attorney General Wallace said was, look, we're unaware if there's any negotiations with the Attorney General and the DA's office, because I'm not handling it. That's being handled by someone on the other side of this confidential wall while that's happening. But Alina Habba, who is under an obligation to tell the court if that's the case. But her letter basically sets out the opposite, right? But I have a theory about why she did. She basically said, she wrote a letter that said, oh, I consulted with my ethics counsel and I'm constrained by providing more detail. Yes, my office represents Weiselberg on the civil matter, but we have nothing to do with the criminal. And I haven't discussed anything with the Manhattan DA's office. But she says, my ethics counsel says I can't give more information. First of all, that's not true. That misstates the law. But what I read from that is basically she knows Weiselberg lied. She knows and he probably admitted to her that he lied. And she's trying to figure out, what do I do? Because I have an obligation to the court, but I also have an obligation to my client. And so in some ways, by answering that way, by saying that for ethically speaking, I can't say anything, she's basically admitting that he did lie and she knows he lied. And I'll give you an analogous example. When in a criminal case, for example, if you're a defense attorney and you have a client and they told you a set of facts, and then they said to you that morning, I'm going to testify and I'm going to say a different set of facts, as the lawyer, I have an obligation. I can't call my client to the stand and allow him. I can't knowingly ask him questions knowing that he's committing perjury. But I also can't, because of attorney-client privilege reasons, I can't sell him out to the court. And so the way I handle that, the way attorneys handle that, is they say, they stand up and they say, Your Honor, my client has a statement with which he would like that he wants to make to the court. But I'm not going to ask him any questions. He is going to make a statement to the court. And the attorney steps back and sits down, because they are not suborning perjury. They are basically saying, my client is doing this and I'm not participating. And so everyone knows what that means. It's like code to the court. Hopefully the jury doesn't know, because you don't want the jury to be tainted. But it's kind of code to the court that he's lying. And so I read her letter to also be code. And she's basically saying, he lied, I can't say anything, but I'm basically admitting that he lied and committed perjury. And so that's what I think she was doing there.
Yeah, I think she's got a suborning perjury problem. The problem that they have is they've walked into the trap that's been laid by Judge Engoron. Judge Engoron didn't say that he took it as article of faith that the New York Times article was accurate reporting. He asked the lawyers, who are officers of the court, to give him the facts or information required for him to assess as the trier of fact whether we have a perjury problem and a suborning perjury problem in the courtroom. And instead, Cliff Robert ran out and did a crazy response, attacking the judge's ethics, of all things. Talk about the pot calling the kettle. And then, of course, they always love the whataboutism. You know who is a perjurer, Your Honor? Michael Cohen is a perjurer with no record cite, just an exclamation mark. He perjured himself in front of you. Where's the citation of that? Where is the proof of that? Nothing. It just undermines their credibility every time they write something into the court. And what the judge, I'm sure, is going to respond is, thank you for your submissions. The Trump lawyers seem to have missed the boat. I'll take Ms. Habba at her word that she cannot tell me more based on her ethical obligations, but also I need to get to the bottom of whether whether perjury has happened in my courtroom, independent from whether the crime of perjury is being prosecuted by the Manhattan DA. I have my own independent obligations as a judge to determine whether, as the trier of fact, somebody lied to me under oath. So I'm going to hold an evidentiary hearing and get to the bottom of it. If Allen Weisselberg wants to take the Fifth Amendment, fine. So the problem is he doesn't have, as we like to say in civil practice, he doesn't have all necessary and indispensable parties in front of him. He has Alina Habba. He has the lawyers for Trump. He doesn't have Seth Klayman, the lawyer for Allen. He doesn't have Allen Weisselberg in front of him again, who probably will take the Fifth Amendment on this particular issue. He doesn't have representatives of the Manhattan District Attorney's Office who may or may not be able to speak. And he doesn't have testimony under oath. You'll note, for those that are watching us, the audience, the letters we keep posting, the letters that were submitted, including the New York Attorney General, it's not under oath. They're not affidavits. They're on letterhead. They're on electronic letterhead of these law firms. So these are naked allegations and argument of counsel without any evidential support. I think they're just walking into the, if I'm Engoron, you can do one of two things. You can take the direction from the New York Attorney General, which is, yes, you got lied to. However, we know he's a liar. He went to jail already. We put him in jail already. The Manhattan DA put him in jail already. He served his time. You know he's not reliable. Get to the decision. Because they're chomping at the bit because they want the ruling. You know, they want the up to 500 million. Somebody said in the chat, why is it only up to 500 million? Well, it's got to be tied to, ill-gotten gains or profit that they should not have obtained. And there was a detailed calculus that was put on by expert witnesses for the New York Attorney General. Yes, the judge can increase that, but disgorgement is not punitive damages, and punitive damages are not at stake here. So there's a ceiling for this with interest, but he could give the benefit of every doubt to the New York Attorney General and ratchet that number up a bit. He could take that lead for the New York Attorney General, which is nothing to see here. Yes, you may have gotten lied to, but you knew you possibly were lied to by Allen Weisselberg of all people. Just issue the judgment. Or you could do what I think this judge is going to do, which is, I don't like the precedent of somebody lying to me in a courtroom, and I can't ignore it. I mean, I can't just cover my eyes, and my justice is blind, but it's not deaf and dumb. And he's going to have to do something about it because I think it just sets terrible precedent in the future for if they quote unquote get away with it. And he doesn't know the answers, and he hasn't gotten any more information that's going to allow him. Like if you and I, God forbid, if you and I got a letter like that, or email like that from a judge, you and I would prepare like a declaration, an affidavit under oath, that we didn't do anything wrong, and this is what we knew, and this is what we didn't know, and within the limits of our ethical obligation. Not these guys. If I'm Engoron, I hold that hearing, and maybe I don't hold up the judgment any longer, because the answer to it doesn't really. He can say, I am going to make my own credibility decision, but this is a different issue about whether he got lied to and whether lawyers were responsible for it.
Yeah, I completely agree with you. I think he separates it, though. I think he has a hearing. And one of the things I just want to mention is people in the chat are asking, what word are we using with suborning perjury, supporting it is a weird word, right? It's SUBORN, and it essentially means to obtain testimony from a witness or to induce testimony. And so that it's just a different word that is used in the phrase for perjury, just to
with
clarify.
a B like boy, suborn. Yes. It's one of those things that, this is why we spent a lot of money to go to law school, so we knew what that word was. Well, if you like that kind of debate at the intersection of law, politics, and justice between two lawyers who know what they're talking about, how novel, then you're going to love Legal AF. and the title is exactly what you think. We do it every Wednesday and Saturday. One place and one place only. Don't change that dial. MeidasTouch Network and their YouTube channel. 2 million strong free subscribers. Help them get to 3 million before 2024 is over. If you know all about us and you're part of our audience, we thank you from the bottom of our pod. Take that clip, send it off to friends, family, and those in your life and say, hey, you know that podcast I've been telling you about? Here's a clip. You may enjoy it, and maybe they'll join our ride as part of theirs. If you have no idea what I'm talking about, I'm Michael Popok. That was Legal AF. And we invite you to join us on Wednesdays and Saturdays at 8 p.m. Eastern Time, and then on audio podcast platforms of your choice. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.